David Greene, the Civil Liberties Director at the Electronic Frontier Foundation, a nonprofit digital rights group. He joins us today from San Francisco. David, so DeSantis is saying that he is expecting legal challenges. On what grounds?
Well, I probably most prominently will be on First Amendment grounds. And there are two main First Amendment arguments I expect that will be made. One would be based on the First Amendment rights of minors to receive information and to communicate via social media platforms. Under U.S. law, minors do have First Amendment rights, and they have them even independent of their children. And so that's one argument that can be made. This law certainly does abridge their rights, and I don't think the state would deny that. The second argument that can be made, the second free speech argument that can be made as well, would be on behalf of adult users who believe that, or who will find that this law will effectively require social media platforms to verify the age of users and will not allow for social media platforms to offer services to anyone unless they know they are of sufficient age to do so. And so therefore we'll have to ask everyone for their age.
Sure.
And so adult users who want to be able to use these sites without proving their identity or sending private information to these companies will have arguments also that this law infringes their rights, even though the law does entitle them. It doesn't restrict their ability to have accounts, but it does, in effect, create a burden on them to identify themselves and prove their age to do so.
David, just coming back to the First Amendment rights you were talking about, does a child's constitutional rights in that regard trump the responsibility of their parents to protect them?
Well, minors do have constitutional rights independent of their parents. There are situations, and again, it really it will depend on exactly how the state really articulates its interests behind this law. There are situations where parents do have some ability to control what their children experience. But when we talk about the receipt of information and the receipt of legal information, information that's not inherently harmful, parents' rights don't always by law trump minors' rights, and this is one of those situations where you could see parents having some role to play. The question is, what role is the government in that relationship?
David, you say things that aren't inherently harmful. I mean, just last year, the U.S. Surgeon General, he issued an advisory on the profound risks of child social media use. I see some apps like Facebook, Snapchat, Instagram, they already prohibit children under the age of 13. Just how much difference will this actually make? Is this just about the age at which children are given access?
Well, so first of all, services currently are completely free to limit their services, right? A service is not Facebook or whatever is not required to offer their service. They could set age limits on their own, and that there's no role for the government in that. The question here is, what is the government's role here? And again, parents can also have their own internal rules in their house about what their children can and cannot do. So that doesn't, those aren't the type of constitutional issues that arise when the government is stepping in and placing restrictions on the use of services.
David, I believe that this particular law in Florida, it bans social media formats based on addictive features like notification alerts or autoplay videos specifically, rather than the content itself. So it's targeting that rather than access to information for children. Does that change the legal argument here?
Well, it makes the legal argument. How the case will be argued will get changed. It doesn't change the nature of the. That doesn't change the fact that the court will have to, that the state will have to justify this under the First Amendment. The level of scrutiny might be the level of scrutiny will subject the law to might be a little different if the court finds that this is not a law that's concerned with specific content, but that only incidentally affects content. But some of these things that can trigger the law, such as continuous loading or seamless content or even push notifications, or the showing how many likes a post had, or autoplay, things like this are actually speech functions. Those aren't things that are neutral to speech. Those are things that are about people getting information, and that's typically the type of regulation that we will subject at least to intermediate scrutiny under the First Amendment. So they'll still have to have there will still be need to to prove that this law is adequately tailored to address the First Amendment interests.
Well, we will see how this plays out in the coming weeks and months. David Greene, the Civil Liberties Director at the Electronic Frontier Foundation, thank you for joining us on Al Jazeera, sir.
Thank you for having me.